Hi everyone, my name is Nicole and welcome to the Employment Law webinar on the role of government agencies. This webinar is part of a series of webinars developed by Liquid HR designed to provide you with all of the information that you need as an employer to ensure that you're compliant with the Fair Work Act, modern awards and associated regulations. So as mentioned today, we're going to have a look at the role of government agencies. We'll begin by having a look at the Fair Work Ombudsman and what role they play that you may interact with from time to time. We'll then have a look at the Fair Work Commission. The Fair Work Commission was previously referred to as Fair Work Australia. We'll have a look at the Australian Human Rights Commission, as well as referencing some of the state bodies that deal with human rights. And we'll also have a look at SAFEWORK Australia and the relevant state bodies as well. So let's get started and have a look at the Fair Work Ombudsman. So the Fair Work Ombudsman came into operation in 2009, so 1 July 2009 with the Fair Work Act, and it was established for two primary reasons. The first and foremost is education. So their role is to provide advice to employers and employees regarding their rights and obligations under the Fair Work Act. So that's in regards to determining what award applies, so award coverage, looking at minimum wages, employee entitlements, anything under the National Employment Standards. So they have a number of resources for employers to support them with making sure that they are meeting their employment obligations. There's probably a few good resources from the Fair Work Ombudsman that I might just mention here that you may want to check out. So the Fair Work Ombudsman has what's called as a pay and conditions tool. Sometimes you'll hear people refer to it as PACT, and it can be a useful tool to guide you in determining award coverage as well as the pay rates for your employees. They also have some online training courses that you can access for free around different topics, as well as a number of templates and guides that you can access. I will note, obviously it's important to point out that they are generic resources, but they may be a helpful starting point if you don't have anything at all. The second role of the Fair Work Ombudsman is from a compliance perspective. So they will investigate any complaints or suspected breaches of workplace laws, awards and registered agreements. So they do this in a number of different ways, and we'll touch on that shortly. So let's have a look at Fair Work Inspectors, and they're the people who will investigate any complaints and what their role is. So Fair Work Inspectors primarily perform their role one of two ways. The first way is they actually have the right to enter your workplace if they believe that the Fair Work Act or an award or registered agreement has been breached. When they do come to your workplace, there's some certain rules they need to follow. So they actually have a Fair Work Ombudsman issued identity card that they need to provide you with. But when they do come on site, they're actually able to inspect any work, process or object related to the breach. They can actually interview anyone in your business provided that person gives their consent. They can take copies of documents that are related to the suspected breach. So often they will only come on site if they have evidence or if they have a reason to believe that there has been a breach. The second and probably more common one that we see is where they will issue you a written notice to produce records or documents. So this may be, for example, they may have received a complaint from an employee that they've been underpaid. It may be an anonymous complaint, or it may just be part of a review that they're doing of a particular industry. So what they'll do is you'll get a letter from the Fair Work Ombudsman and they will request you to submit particular documents. Normally these are in regards to the records that you're required to keep under the Fair Work regulations. So it would be information around time and attendance records, minimum wages paid, any penalties paid, etc. They have to give you at least 14 days to produce those documents. They don't normally advise you the reason why. It will just state that as part of a review. You really need to comply with that written notice. If you don't, the Fair Work Ombudsman actually has the powers to recommend litigation for civil penalties. And those civil penalties can vary depending upon whether it's an individual or corporation. So at the moment, for an individual not complying with it, it's $12,600, and for a corporation, it's $63,000. If you get a request from the Fair Work Ombudsman and you feel as though you can't get all those records together within the time frame, it's best to reach out to them and ask for an extension. So the key point there, don't ignore it, follow it, work with the Fair Work Ombudsman and provide the requested documentation. If a Fair Work inspector does undertake an investigation, there's a number of different outcomes that can come from that. So we often get questions from clients around the Fair Work Ombudsman's requested this information, we've provided it, we haven't heard anything, what's going to happen? So with that in mind, it's important to be aware of what the possible outcomes are of a Fair Work Ombudsman investigation. So the first thing is in regards to a compliance notice. So a compliance notice is really a non-punitive mechanism for the Fair Work Ombudsman. If an inspector believes there has been a contravention of the Fair Work Act, they can actually issue a compliance notice to an employer or to an individual, and it will outline what needs to be rectified by when, and a requirement for the employer or individual to produce evidence to show that it has been rectified. If the matter is then rectified and evidence is provided to the Fair Work Ombudsman, then that is the end of the investigation. The second one, or second outcome, is an enforceable undertaking. So an enforceable undertaking is an agreement between an employer and the Fair Work Ombudsman, where the employer agrees to undertake a number of activities to rectify an issue that was identified. These enforceable undertakings aren't always used, but they are an option to the Fair Work Ombudsman. They often contain very detailed requirements or onerous requirements for the employer and what they need to do to be able to rectify a matter. If you haven't seen one before, I suggest if you just Google enforceable undertaking Fair Work Ombudsman, you should be able to see some previous ones that are in place. They often include things like rectifying any underpayments, an obligation to the report to the Fair Work Ombudsman on a regular basis, an obligation to get external audits by an independent third party undertaken on a regular basis, and that data produced to the Fair Work Ombudsman. Sometimes they include a requirement to have a formal apology published somewhere, so they can include a number of different things, but it is an option the Fair Work Ombudsman has. The third option they have is what is called an assessment letter, and this is normally just a notification at the end of an investigation. So if you have a Fair Work inspector who's undertaken an investigation and they need to advise you of the outcome of that assessment, it may state that there's been no contraventions identified and then the matter is being closed, or in some instances they may state that there is insufficient evidence and they may seek further information, or they may advise the parties to seek independent legal advice. For the fourth option, there's what's called an infringement notice. So if you have a Fair Work inspector and they reasonably believe that there has been one or more contraventions of the Fair Work Act or the regulations, they may issue an infringement notice, and that requires the person or the corporation to pay a penalty notice. That can be $1,260 at the moment for an individual, or $6,300 for a corporation. An infringement notice can be issued up to 12 months after the contravention has occurred. Lastly is litigation. So litigation obviously meaning legal proceedings. The Fair Work Ombudsman will only commence proceedings if it considers that they have sufficient evidence, and also the other thing they look at is it in the public interest to do so? We need to remember that the Fair Work Ombudsman is a government body and therefore it's funded by taxpayers. So that means any legal action it's taking is being funded by taxpayers. So they have to have a look, is this the best option, or could we use one of the options above, 1, 2, 3, 4, to get to the same outcome? They're more likely to litigate in cases that involve deliberate or repeated non-compliance, if there's been exploitation of vulnerable workers. So when I refer to vulnerable workers there, I'm talking about perhaps people who have English as a second language, maybe working on a visa. If there's been employers who fail to cooperate with the Fair Work Ombudsman and fix contraventions after being given the opportunity to do so. So even in circumstances where contraventions have been rectified, it may also still be appropriate for the Fair Work Ombudsman to commence legal proceedings to obtain a penalty in respect to the contravention. So that's important to be aware of. They're your 5 possible options. So if you do get an investigation by the Fair Work Ombudsman, know that that may be one of the potential outcomes that you would be facing. So let's have a look now around the Fair Work Commission. So the Fair Work Commission was previously named Fair Work Australia. It was renamed the Fair Work Commission in January in 2013 to reflect the role that it plays. It has a number of responsibilities and a wide breadth of what it looks after, but primarily the important things for you to be aware of is they provide a safety net of minimum conditions. So they do that by undertaking the annual wage review, minimum wages in award. So normally that takes place with any increases coming into effect on the 1st of July each year. They review any applications to vary awards. They recently undertaken a large review of awards. So when the Fair Work Act was introduced, there was part in the legislation that stated that every 4 years the Fair Work Commission was going to undertake a review of modern awards to ensure they remained current and streamlined, with the whole view of simplifying the system. That has recently been changed, and they will no longer be undertaking a review every 4 years because the first review has taken years. There's been so many applications by different parties, and the Fair Work Commission has identified that that's not the most effective way to handle the situation. In addition to that, the Fair Work Commission also facilitate good faith bargaining. So they review any bargaining orders around enterprise bargaining. They also review and approve enterprise agreements or hear matters to terminate enterprise agreements. They deal with any unfair dismissal applications, so initially via conciliation. So if an employee believes that they have been unfairly dismissed from their role, provided they've met what's referred to as the minimum employment period, they have 21 days to make an application to the Fair Work Commission. They also regulate how industrial action is taken, so they can issue orders to approve or stop industrial action. The Fair Work Commission also resolves a number of other range of disputes. They hear things in regards to union right of entry, transfer of business provisions, bullying, adverse action, among many others. So generally all of this is managed via conciliation or mediation, but in some cases via public tribunal hearings. The Fair Work Commission has a wealth of resources for you as an employer, and I really encourage you to jump onto their website and have a look at some of these resources. They actually have the Fair Work Commission YouTube channel. This contains things like mock trials, lectures. They have other resources. Particularly if you have an application from an employee, it's always good to go and have a look in terms of what you should expect if you have to go to the Commission. They have what they refer to as bench books. So these are really detailed guides on certain topics. So the topics are around enterprise agreement making, around anti-bullying, industrial action, unfair dismissal, that was just recently updated in January 2020, as well as general protections. They have fact sheets, guides and videos, and I've popped the link up on the screen there for you to have a look at. They also have practice notes that provide an overview of the Fair Work Commission procedures, so you can make sure you're familiar with that if you have to go to the Commission. One of the key things I always encourage all our clients to do is, if you do have a modern award that applies to your workplace, or a number of different modern awards as it may be, if you're currently relying on a paper copy, throw that out. Modern awards are updated so often that if you're using a paper copy, it's likely that there's a provision in there that has been replaced. So I really encourage you to always refer to the Fair Work Commission for an updated copy of the award. And I would also encourage you to actually go in and sign up for any updates of changes to that award. So if the Fair Work Commission makes any amendments to clauses, if there's any changes to penalty rates, wages, any of the terms and conditions, you will receive an email from the Fair Work Commission advising you of that change. And that's a great way to keep across the changes in the award. In terms of the Fair Work Commission, so if they do have a public trial or a hearing, there's 2 primary outcomes in terms of how they may settle matters. The first is with what we refer to as the terms of settlement. So if I give you an example, let's say, for example, you have an employee that you terminated for performance issues. That employee believes that they were unfairly dismissed, and they make an application to the Fair Work Commission within that 21-day period. The matter is then heard via conciliation, which will involve a conciliator from the Fair Work Commission calling both the employer and employee and talking around how you can resolve the matter. If it is agreed that the matter can be resolved in that conciliation, the terms of that agreement are documented in a terms of settlement. So the Fair Work Commission will develop that, they will issue it to both parties. Both parties sign and execute the agreement and then send a copy through to the Fair Work Commission. The second way is via a decision or an order issued by the Fair Work Commission. So if a matter can't be resolved in conciliation, it goes to a hearing, the Fair Work Commission can hand down a decision or an order, ordering one party or another party to do something. So if we look at unfair dismissal again, the matter's not resolved at conciliation, it goes to the next level, there's a hearing, the Fair Work Commission determines an employee has been unfairly dismissed and issues the employer to pay that employee compensation. Once they've issued the order, that's the end of the Fair Work Commission's powers. So let's say, for example, the employer refuses to pay that once the Fair Work Commission has handed down that order. To enforce that order, an employee actually needs to commence civil proceedings. So they can do that in the Federal Circuit Court of Australia or a state magistrate's court by commencing a small claim. So that's a small claim is only up until $20,000. They can enforce it via the Fair Work Division of the Federal Circuit Court of Australia or in an eligible state or territory court. Okay, so let's move on to our next government body that we're going to be looking at today, the third for today, and that's the Australian Human Rights Commission. So the Australian Human Rights Commission is an independent third party, and it's a federal body that investigates complaints about discrimination and human rights breaches under federal anti-discrimination legislation. So it can deal with any complaints in the workplace in relation to sex, disability, race, or age. The important thing with the Australian Human Rights Commission is that it can only resolve complaints via conciliation. So if the matter can't be resolved via conciliation between a conciliator through the Commission and the employer and the employee, the complaint is terminated by the Australian Human Rights Commission, and the individual then has 60 days to lodge their complaint with either the Federal Circuit Court or the Federal Court of Australia. It's also important to note that the Australian Human Rights Commission is the federal body, so it covers only federal anti-discrimination legislation. There is also state legislation in relation to discrimination, harassment, bullying, and each state then also has a relevant body. So if we have a look in New South Wales, for example, there is the New South Wales Anti-Discrimination Board, and they administer the New South Wales Anti-Discrimination Act 1977. So similar to the Australian Human Rights Commission, they can only resolve complaints via conciliation. If the matter can't be resolved, the complaint is terminated and the individual can take their claim to the New South Wales Civil and Administrative Tribunal. So it's important to be aware that employees can actually choose what body they go to. So if they are in New South Wales, they can choose whether they're going to make their complaint to the Australian Human Rights Commission or the New South Wales Anti-Discrimination Board. The next body to have a look at is SAFEWORK Australia. So SAFEWORK Australia is the federal government body responsible for driving the policy development in relation to work health and safety and workers' compensation. However, many people think SAFEWORK Australia as a federal body is responsible for regulating work health and safety legislation. That's actually not the case. The Commonwealth states and territories retain responsibility for that. So in New South Wales, for example, there's a body called SAFEWORK New South Wales. They're responsible for investigating work health and safety complaints, and they can also prosecute employers through the courts. So similar to the Fair Work Ombudsman that we discussed earlier, they have inspectors who can issue improvement, prohibition, or penalty notices. So improvement notices are those notices where you may need to rectify something, but work can still continue. So you would get a notice from SAFEWORK New South Wales saying this needs to be rectified by this date and you need to provide the evidence. Prohibition notices are a little bit more serious. They tend to be a requirement on an organisation to stop a particular type of work until the matter is rectified. So let's say, for example, you work in the scaffolding industry. and SAFEWORK New South Wales determines that your scaffolding is a health and safety risk, they will actually issue a prohibition notice to say that you can't perform any further work until that matter is rectified. The last one that they have is in regards to a penalty notice. They can be issued for certain serious offences. So an example might be if you remove asbestos without a licence. So a penalty notice will require an employer or an individual to pay a penalty for breaching work health and safety or workers' compensation legislation. The state bodies that I referenced, so as I mentioned, New South Wales is SAFEWORK New South Wales. I've also listed the bodies for Queensland, Victoria, ACT, South Australia, Northern Territory, Western Australia and Tasmania. So it's really important to remember that work health and safety and workers' compensation is enforced and regulated at that state-based level. Just a reminder, don't forget to check out our other webinars, which are available in the Knowledge Centre on our website. So we've covered a number of different webinars throughout this series and hope that you find them helpful in getting a really quick snapshot of some of the key provisions of the Fair Work Act and your requirements as an employer. Always, if you have any questions, please don't hesitate to get in touch. Our phone number is on the screen and our email address, and we'd always love to hear from you. Thanks.